Hi, everybody. Welcome to this last panel, Emancipation, Strategy and Tactics. We're just going to jump right in. I'm going to say my name. I'll say the names of the people who are here with us, although you can read it. And we're going to get started. So so I'm Dan Farbman. This is Amna, Akbar, Amy Cohen, Jocelyn, Simonson. And just a word of framing for sort of what we're going to talk about. In one of the panels yesterday, Angela Harris raised a couple of questions sort of for the community that have been sitting with us and that we've sort of heard iterated in various other moments. And so these are questions that I don't think we'll answer, but have been part of what we were thinking about as we were thinking about what we would say anyways. And so they were basically, the basic question was, what are we doing here? And one way of asking that is like, are we just gathered here together in a way to like find a community to broadcast our work out into the world? Are we trying to change something? If so, what are we trying to change? And if so, what is our theory of change? And then related to that, what are we doing together, right? So back to the question of what are we doing together? Is there some, as lawyers, as people in the legal academy, as people adjacent to the legal academy, what are we doing together? So those are questions that, again, I don't think we have answers to, but are animating the kinds of things we'll be talking about. So without any more delay, I'll turn it over to Amy.
Thank you all so much for being here at the last session, and deep thanks to the organizers. This has been an incredible weekend. All right, so I'm going to talk today about a project that I've been working on with Bronwyn Morgan that examines prefiguration as a strategy and a practice of social change. So as a practice of social change, prefiguration does not entail a great rupture miraculously coordinated from above, or really even a mass movement revolutionary ground swelling from below. Rather, it entails the accumulation of millions of everyday practices that presuppose current economic structures and yet call forth new social worlds. So our project specifically asks whether it makes sense to prefigure forms of legality. And we know this is a potentially paradoxical question. So in social movement practice, the term prefiguration has anarchist roots. People describe prefiguration very simply as being the change you want to see, and so implementing the world we wished we had in the here and now, in the means of struggle. So for this reason, prefiguration often involves people trying to build autonomous forms of social life outside of statist and outside of capitalist institutions, and specifically their means, ends, rationalities. For us then to speak of prefigurative legality might therefore seem paradoxical or surprising. But we observe people doing things in the world that we think are well described by this paradoxical term. So these are people who play with law, working within legal rules to transform them. These folks don't necessarily oppose or defy law. They also don't necessarily advocate for law reform. Rather, they use legal techniques to translate criticisms of the status quo into new legal rules and practices that act as if alternative worldviews have already been enacted. So we suggest that it's often in such moments of alternative play that strong critiques of the current order and new transformative worlds are imagined and sustained. So we anchor our discussion of prefigurative legality in our friend Amelia Thorpe's book, Owning the Street, The Everyday Life of Property. So Owning the Street describes Parking Day, a day that since 2006 has occurred in cities around the globe where activists claim space designated for car parking and repurpose them to meet very different social needs. For example, a parklet where people can sit and read, or establish a temporary micro vegetable garden with a seed share, or a health clinic for day laborers with a barbecue and some fruit. We have just show some pictures. There are three. So participants frame these interventions as legal. They engage with government claims to control the space. By paying the parking meter and receiving a ticket, people hold themselves out as entitled to repurpose space otherwise devoted to cars. In colloquial terms, they insist they've leased the space and therefore are free to put it to new uses that enact in the present at the same time as they limn for the future a vision of a society with very different public streets. So we build from Parking Day as well as other examples. We spend a bunch of time on people's tribunals, some alternative judgment projects, and we try to sort of derive 4 characteristics of prefigurative legality, really just in an effort to bring more consciousness to what we see as a distinctive, if also kind of tricky legal practice. And I'm just gonna kind of sketch them quickly here. So the first characteristic is pluralism. So like Amelia's interlocutors, people may exploit the fact that what sounds like an unambiguous or official meaning of a term, a lease, has different practices responsive to this term. Now, of course, the idea that law is what people do with it on the ground is a basic, realist, critical, and socio-legal insight, but it's how people use this sense of possibility to enact desired futures in the present that prompts us to describe their interventions as examples of prefigurative legality. So we call the second related characteristic acting as if. So here we want to capture some of the feeling of liberating oneself from the constraints of false necessity, to invoke Roberto Unger. So when people use law in ways that defy any likely official authorization, they're acting as legal subjects oriented not towards making demands on the state, but proceeding as if they already have legal power. In Australia, the Pay the Rent movement and the Aboriginal Tent Embassy are 2 examples. We describe people acting as if they have sovereign legal power. The third characteristic describes how people may act notwithstanding their loss of faith in law reform to secure progressive effects, at least in the short term. So for this reason, people may bring a playful sense of experimentation to temper their skepticism with some hope that legality nevertheless remains a desirable pathway towards progressive social change. Sometimes this play is very lighthearted. Sometimes it carries the intergeneral pain of colonial dispossession. But people continue to draw on law's modes of legitimacy and status, right? Like Amelia's interlocutors, people may engage in transgressive interpretations of law, but without seeking to break or fundamentally undermine its social authority as a governing principle, and yet at the same time without seeking or inviting permission from authoritative interpreters or official decision makers. All right, the final characteristic, acting anyhow and in case, is our effort to try and capture a distinct approach to strategic goal orientation. So people engaged in prefigurative legal experiments don't operate according to a familiar model of instrumental goal setting because they wish to create alternative futures in the here and now. And so they want to dismantle clear distinctions between means and ends, right? This is enacting futures in the present. And yet such actors also often anticipate something beyond what they can currently realize. This something more often follows from the relationships and practices that people build in the present. And this is a form of goal orientation and temporality that's just hard to capture in the abstract. So I thought I'd just read a bit from a judgment from a people's tribunal in Mexico in 2014 that considered, among other things, violence against corn. And just in case you're not auditory listeners, I thought I'd put it up, but I'll read it. The tribunal became a community space, not because it defined an overarching plan and a new faith to follow, but above all, because it began a real process of communication, which allowed those of us who participated in this experience each to be transformed. In that experience, we recreated each other, restoring our hope in the role of words, arguments, and fair reasoning based on ethical principles. In short, it created a new kind of space in which to demand our right to a different Mexico and our right to define our own rights. It succeeded in doing so in a way which made it a very nascent real-life demonstration that this better Mexico is something which is already here and now as something immediately practical and ready for those of us who want things to be that way to keep working at it. So here people labor together to create new possibilities and meanings from existing legal material and legal forms in the present, at the same time often expecting that what happens next is unknown and perhaps even likely to be overtaken by events. Yet they act anyway in case the seeds they are planting will bear fruit of some sort in time. All right. So in the paper, we try to illustrate these 4 characteristics of prefigurative legality in more detail, and then try and put them in dialogue with critical legal studies, as well as socio-legal studies. And here, time is short. I'm just gonna suggest some of how prefigurative legality both challenges and extends one or strands, perhaps, of critical legal studies as a praxis of social change. So a core realist CLS, now LPE method and commitment is distributional analysis. So many of us here are trained to ask how background legal rules accomplish economic distribution. So we can imagine how changing these rules could distribute resources in different ways. Right? Often legal scholarship in this vein analyzes law at a level of national or global power, asking, for example, how, quote, tax law, IP law, labor law, and the plethora of legal structures that have enabled financialization shape global production and trade. And I'm quoting from an IGLP paper that I love because this scaled up level of analysis can generatively destabilize established pathways of reasoning and argument, right, producing insights about exploitation and inequality. And yet we ask you to also consider how it can make prefigurative experiments appear marginal against dominant structures of authority. So prefigurative legality attempts to seduce analysts and practitioners, perhaps you, into experiencing some hope and optimism about, quote, the constitutive power of small and local processes, to quote J.K. Gibson Graham, but perhaps also to in turn invoke Willie's example on the last panel of experimentation and the production of constitutional identity and practice within unions. And here, prefigurative legality offers tools to both retain and rescale, or really multiply scale, the critical legal impulse to use law to unsettle necessary institutional arrangements. This kind of hope requires one to sort of relinquish a singular instrumental understanding of law that emanates from a consolidated source of state or corporate power that only some imagination of mass organized resistance can bend. Instead, it pulls into focus how people use legality to create new felt experiences of individual and collective agency, so that scale becomes not a question of quantity as much as a social question of self and collective identity, to paraphrase a recent really beautiful APLA keynote by Carol Greenhouse. All right, so here, prefigurative legality extends a particular early substrand of CLS, one that insisted upon the powers of shifts in subjectivity to catalyze changes in economic and political systems. Recall that Peter Gable, who I miss, argued that how law distributes reflects the degree of social alienation in a society. Or he called for undoing the pact of withdrawn selves so that people could reconnect to their natural desires to live in common. Recall that Patricia Williams proposed to reimagine rights as, quote, enabling a drawing near and overcoming of marketplace distance among humans and way back in the day, as well as she argued non-human animals and rivers and rocks. So prefigurative experiments suggest that encoding such imagined solidarities in formal legal institutional garb happens, if at all, only in thinly institutionalized and even hyperlocal settings. So is this a constraint, or does it echo one of the important and iterative ways that transformative social change happens, recalling perhaps the ripple effects of second wave feminist consciousness raising in the late 20th century? Or to put this another way, we know that to a usual, even critical LPE-inspired way of thinking about law and law reform, prefigurative legality is kind of ephemeral. So I'll just quickly conclude with some of the criticisms our project often prompts. So when we think with a particular understanding of structural reform, right, we may expect that state law will directly repress efforts to act as if people have the legal power to experiment otherwise, and especially repress experiments by vulnerable and disadvantaged groups. We may observe the limits of imagining another world by working with the master's tools, for example, paying a parking meter to decommodify public space. We might also note that the energy of as if is politically indeterminate, right? We wrote this paper in a moment when millions of Americans appeared willing to live as if an election was stolen, enacting a kind of wish fulfillment of a highly specific substantive vision, right? So we've described this approach to prefigurative legality marked by left commitments to pro-egalitarianism and anti-authoritarianism and open-ended experimentation. And yet we think there are really pressing questions to ask right now about why and how prefiguration animates the political right. So I'll just finally say that as analysts, we too are acting anyhow and in case. So we offer this project to create space for identification among left legal scholars and organizers to again invoke Gibson Graham. So Amelia showed how ordinary people use common understandings of property to bring new understandings into being. And we thought this was such a significant achievement, both in socio-legal analysis and in city building. And it's an achievement that rests on a form of legal scholarship that's just willing to suspend skepticism about how a series of tiny temporary interventions that play with law may coalesce into structural change. So we offered the term prefigurative legality as if this is already a field of scholarship and praxis and a set of strategies that might expand prefiguring our hope in so doing.
Hi, everybody. It's so nice to see you. And it's been such a pleasure over the last few days to be in conversation with everybody. I'm going to talk today about just sort of in the interest of getting small and local and maybe telling one story. I'm going to talk today about one story that I'm telling in a book that's going to be coming out later this year called Radical Acts of Justice. And the book is actually not meant to be about, small stories about one case. It's about social movements and collectives of people engaging in tactics that go to the site of domination, especially legal domination, especially criminal courts, but also, city councils and state houses, and intervene in the system through helping individuals, but also by doing so, create some of the fissures in the status quo that we've been talking about in other sessions, and in particular, work to undermine the ideology of the carceral state and the criminal system, without which it can't really stand, or to think about Jonathan Simon's myths that he talked about on our first day. Bring forth counter myths or counter stories, especially when it comes to the concepts of justice and safety. So you could put up really quickly, the book talks about a series of tactics: community bail funds, court watching, participatory defense, people's budgets. All of them have deep historical roots, and most of them involve intervening over time in lots of different cases or in a big budgetary vision. So for example, a community bail fund will pay bail many times, hundreds of times, thousands of times. And in doing so, bring out counter ideas of the meanings of justice and safety, meanings that cannot be reconciled with the system as it is. So in this way, I think about these tactics as a form of collective contestation. If we're thinking about them as a democratic practice, I think about them as agonistic. They're using the tools of the system, but bringing forth radical ideas that cannot be squared with the status quo and with current ideology. And they're inherently collective, they're ephemeral. And what I want to just talk about for a few minutes is one story that I tell in the book that actually is about a specific case and isn't about a long historical practice of a collective defense campaign in Manhattan that recently ended with the dismissal of a homicide charge. We can put up the next slide. And it involves Alvin Bragg, who's been in the news lately, the district attorney of Manhattan, but in a very different way. So it's one story, one single case, but telling a collective ideological battle. And I was inspired to go to this story precisely because of Amy's ideas about prefigurative legality and sort of getting small as a way of thinking big. It's possible some of you know about this case, and it's possible some of you don't know about it, and I won't be able to do it justice in 5 minutes. But this Tracy McCarter is a nurse who was charged in right at the beginning of the pandemic in 2020 with homicide, with murder, for killing her estranged husband who had been violent toward her over multiple years. And she was acting in self-defense, but she was charged with homicide. And at first, the news about the case was, you know, like a daily news or post headline about a stabbing on the Upper West Side. And that was sort of the story. And she was incarcerated at Rikers Island for many months, 6 months or so. And her case ended up dragging on for more than 2 years. And then in December was dismissed and went through multiple district attorneys before it got there. And Tracy has been really generous in speaking with me over the years, and also organizers who've been working with her have been really generous in speaking with me. And so I want to talk a little bit about the collective defense campaign for Tracy McCarter that without question led to her case ultimately being dismissed, although certainly other factors are involved. When Tracy was initially at Rikers, Survived and Punished New York, which is a coalition, and then within it part of a national coalition called Survived and Punish, which organizes alongside and on behalf of criminalized survivors of violence, and also thinks more broadly in abolitionist terms about the criminalization of marginalized people, especially Black women, trans women, and gender nonconforming people. And in doing that organizing, a lot of it involves collective campaigns around individual cases like this case. And so the practice of collective defense that Survived and Punished New York engaged in ran parallel to lawyering that was happening in criminal court. Tracy McCarter ended up having wonderful lawyers who were not part of this organizing. They were running in parallel. And at first, the campaign involved things as simple as meeting weekly by phone with Tracy to talk about her case, to help understand what was going on, to connect her to her family, or even just to have, not just, but to engage in letter writing campaigns to get people out in the public, to let them know that people were thinking of her. It involved a Twitter campaign asking people to hashtag Stand with Tracy at a time when there was a district attorney primary going on. Alvin Bragg was one of the people running. He eventually won, and he tweeted, "I hashtag Stand with Tracy," while he was running for office. And then he won, and then he took it back, but he tweeted it. But it was there, and because he had used that hashtag, it then became a rallying cry once he got into office and did not dismiss the case. Tracy eventually won a motion to be released, and in the lower left, you can see her. That's half of her Survived and Punished team in her backyard. She was still confined to her apartment at that time. So this group met with her once a week for over 2 years to support her in her case, engage in their own political education. They did readings together. They thought about the criminalization of Black women. They thought about different definitions of feminism, but they also just engaged in a lot of everyday material support for someone who's had gone through incredible trauma, especially at Rikers Island, and was going through incredible trauma. And they also packed the courtrooms for 2 years. I was in a lot of those courtrooms, always wearing the red. So just to note that the only reason they were able to pack the courtrooms because they had the constitutional right to be there. Otherwise, they surely would not have been in the room. And then here comes Alvin Bragg. He takes office. He doesn't dismiss the case. The thought was that he was going to. And this was at the beginning of 2022. The case had already been going on for 1.5 years. And so then the public campaign escalated. Tens of thousands signed a petition asking Bragg to dismiss the case. The coalition grew and grew into lots of groups, really a broad coalition that also went beyond survived and punished, got behind this case. Eventually, Bragg did file a motion to dismiss Tracy's case, a motion that was denied, and then I'll get to in a minute. How much, what am I at? Halfway? 2 more minutes? Okay. 2 more minutes. So on the one hand, just to sort of pause and thinking about the prefiguration that was going on. At a time when Tracy McCarter was being prosecuted in the name by someone who was first by 2 different people who were elected by millions of people in Manhattan to do justice, right? That's what district attorneys do. At a moment where she was being prosecuted in the name of justice and in the name of the people of the state of New York, the survived and punished group was actually prefiguring and living out in very concrete ways what it could mean to support somebody who survived violence. Now we're also talking about the violence of incarceration and prosecution through the collective, weekly, daily caring for each other and connecting that care to broader visions of how we could live in a world where we're not using cages to deal with violence. So they're prefiguring that. And then there comes this moment that I'll just talk about for 60 seconds, where it also becomes a legal battle, literally over the meaning of the word justice. So in New York, as in a lot of places, you can move to dismiss a case in the interests of justice. And Bragg technically moved to dismiss the case in the interest of justice, although he did it in 1 double-spaced page where he explained why. And then Tracy's lawyers filed a very long motion also asking to dismiss it in the interest of justice. And the judge denied the motion. But when she denied the motion, she did it in a courtroom filled with people in red shirts who had themselves articulated in the media, on Twitter, and now in a legal motion, a different concept of justice. And the judge didn't just take 1 double-spaced page. She took her time explaining why that was not justice and why waiting to have a trial and potentially put Tracy in prison was justice. And it was this moment where the court actually was literally contending with this ideological battle that had been set up between whether justice can happen in criminal court or justice can never happen in criminal court. Totally irreconcilable, it totally can't be reconciled. And yet here the judge was addressing it, especially because there was a statute that said you had to consider the public in figuring out what justice is. So she denies it. 6 months later, eventually the case does get dismissed from another motion from Bragg. And the judge again writes a long thing describing how she's reluctantly dismissing the case, especially because all the public support shouldn't mean that the case gets dismissed. And so on the one hand, I know I sound excited like it's this beautiful ideological battle, and in some ways it was. But in no way was justice served by this entire, more than 2 years of punishing, criminalizing a survivor of violence. And so on the one hand, it shows this ideological battle, the kind of fissures that can come up. And I think even in the kind of constitutional fissures that we've been talking about more broadly. And on the other hand, it just illustrates in really stark terms the limits of using our existing statutes and definitions even to have those ideological battles. And so I don't think it solves anything, but I do think it opens up questions about the place of individual legal disputes and the kinds of things we're talking about, and the promise of prefiguration to be in conversation with the ideology of the status quo, and then all of our role in that.
Hi, everyone. So I have some prepared remarks that I'll go to in a second, but I don't know, in sitting here, I'm kind of stunned about where to start because I don't want to overdo it, but I'm really kind of overwhelmed and moved by this space and just the weekend, all of the years and years of work, not just by Appeal, Class Crits, LPE, JLPE, the LSA, CRN, and more, but also, of course, the waves of critical legal theorists before us and so on, and to be in a moment where we could all gather in a space, so much so that we could kind of be together share a sense of commitments, but also it being clear that like there are debates and differences within us, among us, on this kind of progressive to left and various kind of spectrums within it is really profound. It feels like an opening, a space to kind of hold dear and sacred and nurture, and that feels like a very deep kind of responsibility. Not because I'm self-deluded with our importance, I think that happens too often among us, but more because I see this in a way as connected to the many forms of collective spaces of resistance, the kind of resistance on the streets in the United States and around the world that are creating a sense of crisis because of the dire conditions under which people are living and the planet being in crisis. And the way that those kind of ruptures, those riots and rebellions are forcing us to be more bold individually and together. And I just want to kind of think about here, kind of how we do that and all the work, generations of work, the ripples, the memories, the afterlives of struggle against extraordinary odds kind of bring us here. And of course, we are an extraordinarily privileged group of people. And yet, I think, there are ways that we should be thinking and contending with how we can support resistance and rebellion on the streets and the organized modes of survival that people do and engage in all over the world. So I'm really grateful for everyone being here. I'm really grateful to Corinne and Raul and Sanjay, Angela Harris, Martha McCluskey, Amy Kopczynski, and so many more people. Thank you for your labor. Thank you for all the work that you did to bring us here today. And I really hope that, this weekend is kind of not the crescendo, but kind of something that helps us to build and get deeper. Okay, so I'm working on a project about non-reformist reforms. I'm hoping it's going to be a book, but I have an article coming out in May that includes some of my thinking. So I'm going to share a bit about the article and a bit more about what's on my mind kind of on this Sunday. So the premise of the article is in some sense a confrontation of the fact that we live in a bourgeois democracy where the idea of democracy is reduced to a vote and a constitutional system. Political equality enshrined in the most minimal of ways, constantly subject to infringement and disenfranchisement, defined by capitalist social relations and the economic coercion and concentrated power specific to our times and co-produced by a world historical prison and military industrial complex. Social problems are not solved, but become increasingly monstrous as they're channeled into the market and the prison to solve, each with distinct and sometimes conflicting logics that are mutually reinforcing. But human need is not the prevailing logic of either. Profit, pillage, and punishment are, and the relations of race and gender condition and reproduce their expression spatially, bodily, culturally, and psychologically. In the battles against critical race theory, I can't help but repeatedly return to Charles Mills's essay about white ignorance and amnesia about the histories of enslavement and settlement, or as Adolf Reed recently encouraged in his slim memoir, the most recent regime of racial control undone, Jim Crow de jure segregation. I take from this in part the necessity of taking on what we ignore, what we avoid, what lurks in the corners, that's all around us, but we cannot say, as a central part of what we must say and talk about if the work is in part not simply to understand the world, but to undo it. Christopher Tomlins also reminds us that in the essence of the commodity form is forgetting. What does it mean to remember and recall? As many of you have talked about so powerfully all weekend, contending with the combination of politics and the economy, how to take on the classic Marxist critique that the distinction is something capitalism requires, and our place in the system, minimally as a part of the professional managerial class, central as our work is of proposing and promulgating reforms, and understanding that the role of reform in some real sense in times like these of riot, rebellion, and unsteadiness is counterinsurgent. It's only to the extent at which we resist that and try to move in opposition to it that it might not be. And to resist is something we can do individually, but we would be far more effective if we did collectively. We must also consider the social, as Angela Harris often reminds us. The radicalism of this gathering is, of course, a product of the period of riot and rebellion and crisis in which we live. Today, social movements are contending with race and capitalism in ways from which we might learn. They're challenging formal law and politics for its failure to respond to the many, its incapacity to do that, its refusal, its consistent refusal to do it. While it makes sense to view the return of the debate about race and class or race, class, and gender as tired and old, and it would not make sense to see these debates as new, It is also true that the debates have a quality of now, and it's kind of amazing that they're back because it means we're talking about racism, capitalism, and patriarchy together. The debates themselves are a product of struggles over the meanings of race, class, and gender, the relationship to the terms of life, labor, and death, and that so many of us are contending with the explosive intersecting crises all around. If reform is counterinsurgent in some fundamental sense, what might it mean to think about non-reformist reforms? Many of you have read Gores and Gilmore. You know that a non-reformist reform is reform in service of deep transformation. For Gores, undermining capitalism, gesturing towards socialism, building the power of the working class. For Gilmore, undermining the prison industrial complex, gesturing towards socialism, communism, abolition, democracy, building the power of a whole range of dominated and oppressed classes. This is not simply an idea about better substantive demands, but a society governed by the dominated classes. Centering the question of non-reformist reform forces attention on our theories of change. What is our critique of the world around us, the horizon we're fighting for, and our understanding of what kind of struggle it will take to bridge the two? And of course, what is our understanding of our role in there? As Cornell West wrote in 1991, our work is as lawyers and legal scholars is necessarily defensive and liberal without some connection to extra parliamentary social motion. That's his phrase. So in the paper, I outlined dimensions of the framework that are the framework of non-reformist reform that are particular challenge to conceptions of reformism in the legal academy. Non-reformist reforms require a horizon beyond legalism, meaning they kind of challenge what the legal form and the state form as we know it allow. They require a horizon beyond the rule of law and law and order. They require us contending with all the different ways that power moves beyond and outside in contradiction to what the law says. They embrace antagonism and conflict rather than depoliticization and neutrality. They aim to shift the balance of power in society, and they build mass organization in order to prepare the people to govern. A theory of social change attendant to mass power, hopeful about building a society governed by the working and dominated classes, must ultimately attend to actually existing sites of struggle. I identify in the paper what I think of as three prevailing winds of social movement activity today. One is abolition and decarceration, the second is decolonization and decommodification, and the third is democratization. And for each, I write about particular campaigns that kind of embody these trends. So for abolition and decarceration, I write about Stop Cop City in Atlanta. For decommodification and decolonization, No DAPL, the Standing Rock Encampment, the work of the Debt Collective to cancel student debt and all forms of debt, and the organizing of Casey Tenet's Casey Tenet's in Missouri for social housing. And for democratization, the DSA's twin campaigns for the Socialist Green New Deal and the PRO Act, connecting the need to build economic and political power as co-constitutive. So the three ideas embody an aspiration to disrupt aspects of our juridical order and its fealties to the prison and market. Within each, there are campaigns at the local, state, and federal level. Each has some broad appeal on the public and across domains of social movement activity, and each builds importantly on popular insurgencies. Together, these campaigns reveal a larger concern with building a state, market, and society responsive to popular input and human and planetary need.
So this is so rich, and my initial thought is just to move to you all, but I want to just, as I'm thinking about how to move to the conversation that I think we'd all like to have around these provocations, I'm going to add a provocation of my own, and sort of the basic observation is we are all in this room. We've all come to this room as converts in some way, shape, or form. Some awareness has brought us together. I think as Amna sort of spoke beautifully about, it's not our own processes, it's collective processes, but that's how we've arrived here. And I think one question we can ask is about what we then do with our conversion, or what we then do with our arrival. And so, because I'm a historian and I'm writing a book about these things, I'm going to tell a very quick story to sort of frame that question. So placing us in the 1830s at a time when there were many elite legal actors in the world and there were not very many abolitionists. So this is before abolition becomes a national movement. It's a time when it is still very much at the fringes of American, sort of the American political mainstream. And so in my broader book, one of the chapters of the book is about the moment of the 30s and what happens to convert lawyers, and particularly like mediocre, middling white lawyers, to the cause of abolition, to cause them to change their view of themselves from I am a middling white lawyer to I am an abolitionist lawyer, right? What happens in that moment? So let me just give you one very quick example of this. This is Cincinnati in 1836. So a guy named James Burney, the former slaveholder, is moved to Cincinnati. He's become an abolitionist. He's publishing a newspaper in Cincinnati. And his newspaper is getting traction, but it is also making people really mad. And so in 1836, he has moved his newspaper into Cincinnati, and a group of anti-abolitionists storm his press, take his printing press. This is not his printing press. This is your generic image of printing press. And they throw it into the Ohio River, right? And in the process, they storm through the Black neighborhoods of Cincinnati, burning houses, burning homes, harming humans. And there are people watching, right? So this happens. And there are people watching. So the most famous two people watching at this moment who become radicalized in this moment are Salmon Chase, that's him at the top, and Harriet Beecher Stowe, right? So the story of Salmon Chase's abolitionism, if you want to call it that, it's a more complicated story, we can bracket that, or Harriet Beecher Stowe's abolitionism, similar complicated story, we can bracket it, begins in 1836, watching James Burney's printing press being thrown into the river and watching the violence being done. But there's another person watching, and this is the person I'm writing about. His name is John Jolliffe. And he's just your average lawyer. And he's come to Cincinnati to make his fortune, and he's run for office and failed. And he watches this happen, and he becomes, in his mind, an abolitionist at this moment. He transforms from being a lawyer operating in the world to an abolitionist lawyer. But it raises a problem for him. It raises a problem for him. Well, what do you do once you've become an abolitionist lawyer? He's a guy from Northern Virginia. He's moved to Ohio. He doesn't have a network. He doesn't have a set of practices in place. He could sue people. He could defend fugitive slaves, alleged fugitive slaves, which he does do. But he also engages in sort of the rest of his career is a story of him trying to figure out with what to do with the fact that he's become an abolitionist lawyer. So he connects. The first image here is a guy named Levi Coffin, a Quaker in Cincinnati. There's a sort of white abolitionist movement in Cincinnati. He connects there, he finds connections there, but it's insufficient. It's insufficiently radical for him. It's sort of insufficient to the broader political awareness that he's developed. And so he starts making connections with the person on the bottom is a guy named Peter Clark, who's a Black socialist in Cincinnati, very active in the Black abolitionist movement. But the Black abolitionist movement more broadly in Cincinnati is a movement made up of dock workers. It's a movement made up of the people on the streets watching as the thing that is slavery encounters Cincinnati and fighting it on the ground in complex ways that are beyond John Jolliffe's ability to fully understand, right? But he starts to connect with these people and he starts to build them into his daily experience, build the experience of the Black dock workers, seeing the person on the steamship, pulling them off the ship, claiming their freedom. Jolliffe starts to invest himself in that level of sort of retail radicalism, right? And that changes his practice. It changes the way he is in the world, right? To the point when this last image is Margaret Garner, he becomes Margaret Garner's lawyer. And he makes a set of constitutional arguments, which I won't rehearse now, around being Margaret Garner's lawyer that are grounded in his understanding, not just of the way we talk about law. The way we talk, Margaret Garner famously murdered her children in order to keep them from going back to slavery, the source story of Toni Morrison's Beloved. He starts to not just talk about that in terms of law, but in terms of the broader experience that is foreign to him as a middling white dude from Virginia, but also has become part of his practice to try to find ways into that experience, right? And so I guess I leave us with this sense that I think we're somewhere, all of us, on a path like this, right? Having found ourselves committed to certain things and not necessarily always sure where those commitments should go and how we should use them. And so I think I want to turn that back to us as a way of like reflecting on what we just talked about, but then also open up to the room in a moment when I basically just want to ask us, what is there to say about sort of collectively of the things that have been talked about here that we haven't said yet that we should say before we open things up?
I'm ready to open it up. I think there may be plenty to say, but I would love to hear what what's on people's minds, and then, yeah.
Great. So here is what we propose to do in a slight subversion of the normal conference order, which is to put the questions that we've just raised on the table, but then also to put the broader questions that I led with. What are we doing here? What are we supposed to be doing here? What should we be doing here together? And then give you all a chance to talk to your neighbor for 2 or 3 minutes to begin to think about that, so that then we can come back together and hopefully when we do, we will field questions. If you'd like to ask questions, we'll field them, but also very happy to make this into just, you don't have to say more of a comment than a question. It can just be a comment. That's completely fine too, and maybe better. So take a couple minutes to sort of talk, and then we'll bring us back together and have the conversation.
When you guys open it up, I'll just. Yeah, thank you.
So I will call us back to the collective, if y'all are willing to rejoin us and share your thoughts with everybody. So I think Sanjay has a microphone. So I'm skeptical that I'll be able to, even if I know your names, to see you clearly enough to name you. So just raise your hands and I'll sort of like direct the microphone to you when anybody who has thoughts or wants to say anything. Here in the front. Yeah, Shirley. Yeah.
So So essentially, we didn't want to stop talking, but Amy, Aziza and I were thinking about the tensions across the conference between those who are in specific movements like the labor movement and those who are in abolition in terms of what we view the role of the state to be. So the idea of non-reforms reforms, Amy had said, from Gore's perspective, would elevate class, but there obviously is a conversation with the state. So be curious to see how in each of your pieces you, or the lawyers you study, view the state, and maybe throw in the economy too.
Yeah, so our inclination is to hear more before answering, but
Hey, everyone. My name is Faisal Chaudhry. I guess, I don't know if this is a question or a comment. I guess the thing I wrestle with at gatherings like this is, I think, kind of as a gathering of like a left intelligentsia, I think the impulse is to always connect the intellectual work to what's happening popularly, which granted is like a important, valuable, necessary thing to do. And we are a constituency of, as was just pointed out, both people from movements and also people more rooted in academia. I guess the tension for me is that I think it inculcates the sense from the intellectual side of wanting to gesture towards what's happening on the street, which is fine and perfect, but I feel like in a way, the way we gesture ends up becoming either romanticizing or it doesn't get granular enough about the challenges of what's happening on the street and building collective organizing power. I mean, I can just think of remapping this whole conference onto just being US centric for the moment, trying to digest what's happened with millennial, quote unquote, US socialism since 2016 and its trajectory of new life. And is it dying now? Where is it now? I could imagine a very different way of trying to cognize all of this. Within all of those circles, these discussions about where race, class, and gender connect are in ways deeply fractious, partly when it gets to the question of how we should build like a new political movement. So on the one hand, everyone is like, of course, those things are all in play, but within that movement, there's deep fractures about how to handle all of that. So I guess that's what I mean about romanticizing. If you kind of accessed all of this through that discussion, it wouldn't be enough or sufficient to just gesture towards people's movements, things that are happening on the street. We'd be inside of something that's much more tense, and by 2023 has maybe by this point come apart again.
So thank you all for this. Nico and I were talking about the risk of thinking that some work is prefigurative legality as opposed to prefigurative illegality. The future that we ordain is precisely in opposition to law rather than in terms of law. And that's sort of a existing question of ethnographic work all the time, but I'm wondering whether as legal scholars, we tend to make the mistake a little bit more. Not suggesting it's a mistake, but suggesting that there's a risk.
so as we await more hands, any thoughts amongst us?
I mean, I can say a few things. I mean, on the question of the state, one of the things that's really been compelling to me is, well, I mean, I think the campaign against Cop City is very, very important in Atlanta. And it's been going on, as you all know, for a couple of years. And there have been multiple junctures at which, you know, observing from the outside, and I'll get to the romanticization point in a second, it seemed like that struggle was over for different reasons. Recently, 5 or 6 of the people involved in different aspects of that went on this podcast, Millennials Are Killing Capitalism, which some of you may listen to. And on that, one of the activists credits, he used this phrase, which for a while, I just kind of assumed it was somewhere in Marxist thinking. I looked for it, I couldn't find it. So I'm crediting it to the activists. But if you have a story for me later, tell me, please. They use the phrase multiple grammars of struggle. And this activist says the reason why the campaign at Cop City has been able to survive so many setbacks, internal problems with an organization, tremendous state repression, and more, is because they've engaged in and allowed for multiple grammars of struggle. And he doesn't quite define what that term means, but extrapolating from the podcast and thinking about the campaign, part of what they're talking about is that, I think, is that in that campaign, there are different organizational formations that are moving through and individuals that are coming from different political commitments, including people who are more state-oriented, Black nationalists, for example, the people who are occupying the forest, who are motivated by more anarchist commitments, people who are doing the city hall work, and that those various commitments to different political ideologies are motivating engagement with different strategies and tactics. And whereas one group of people or one formation or one set of individuals working in alignment may be kind of, more prefer one kind of strategy and tactic over the other, they're recognizing the way that those things working together, and as long as they're not kind of against each other in a way, kind of can help move the campaign and sustain it. And so I think there you see a really interesting kind of mix of the way in a very live and active and ongoing campaign, again, facing tremendous repression and great odds, but also with a lot of, impressive kind of wins in a way, a kind of way to think about. Because I think it's about this question, these big political questions about theories of change, about the horizons we're fighting for. And I think sometimes it's easy to think in academic spaces, but also among activists, that if, for example, you're more in the prefiguration vein or they're more non-reformist reform vein, that there's an inherent conflict. But in fact, I think these things, there's a way to understand them in relation. If you read Gore's, Gilmore, or for example, the Red Nations articulation of non-reformist reform, one of the things that's really profound is it's clear that none of them are talking only about reforms granted by the state. Gore's talks about, a labor struggle, so working against capital in the context of his discussion of non-reformist reform. Gilmore talks about all sorts of interfaces with the state and with the prison industrial complex, and is certainly not, she's talking about undoing everything and remaking different possibilities that come out of people coming together in different formations. The Red Nation, literally in their definition of non-reformist reform, talks about how they're talking about things like indigenous seed banks. That sounds more like prefigurative legality or prefiguration, but in their definition, that's part of what it means to do non-reformist reform. And in some sense, that's undoing then the concept of law, or the question of what reform is actually about. But that's part of why I was saying non-reformist reforms are about beyond legality, because ultimately, if the horizon, if the question is emancipation, then we have to know that law is only a partial piece of that. I talked for too long, so I won't respond now to the romanticization question, but we could talk about it later.
Oh, I was
I
really
can do
hoping you
romantic.
would. Okay,
I'll
well,
do
somebody does that. Oh,
You
well,
can
sure,
go,
I can,
I'll
okay,
go.
all right. So maybe I should also start with how maybe I'm thinking about the state in this prefigurative project. And so here I think the impulse just is to constantly decenter, what would it mean to prefigure state form? So, what is the state in this kind of imagination? And so very concretely, I think of work by Davina Cooper, who's really interested in municipalism. So, what's an example of a municipality just acting as if it could participate in particular kinds of boycotts of Israel, or acting as if it could decenter or decertify, gender. So just really having skepticism about what the state is and imagining how to play within state forms from the inside. So kind of not a typical statist imagination. Which, it's a really interesting question. When is prefiguration a form of illegality rather than legality? And the history of prefiguration was a history of, it wasn't illegality as much as just outside, right? It was an autonomous practice. And this project, I'm interested in how people are and why they're playing with legality. So in one sense, it's a way to transgress with legitimacy. We're not squatters, we're leasing the space, but there's something else. There's a way in which legalism here provides a sense of agency, a way of scaling oneself into a story of having a particular kind of power that other forms do too, and illegality does. But I think there's something just important about how people are turning to forms of legalism to do work around agency and identity. That's just interesting, which isn't to say it's conceptually required, just kind of empirically interesting. And I don't know. I'm thinking about Faisal's question about romanticization. I guess just the small thing I want to say is that for me, this isn't a project of kind of social movements have their own theory, right? They don't need it from law professors. But I think there is a way that so I was thinking Aziz mentioned in his panel ways in which folks in elite legal institutions can put up roadblocks, can translate legal practice into forms that require particular kinds of institutions and institutional interpretations that have predictable ends. So maybe this is an inward-facing project to kind of undo how we see and think about what legality is, rather than an effort to theorize how movements see themselves.
Just really quickly on the question of romanticization and gesturing. I agree with that. I think that to the extent being romantic about movements and power building and struggle feels like I mean, I take that to be sort of a negative description of it. To the extent it feels like it's a romantic description, I think in part when it comes at least within the law and the legal academy, that's a pushback and a contrast to law being something that we romanticize and take to be the place to start. So if we start with struggle and collective imaginations that are coming outside of the law or just in interventions in the law, then I think that can help. Again, it's a conflict and a conversation rather than an answer, which I take to be the point of struggle. The struggle isn't the answer. Social movement tactics aren't the answer. They often fail and you have to move on and you have to try something else. As to gesturing, I think gesturing can mean a couple of different things. One, which we would not want to do, is to name check movements going out there that are going on as a way to start off a larger inquiry that doesn't really engage with the collective imagination from those movements or the forms of struggle or the forms of using the law or the forms of illegality, whichever it is. We don't want to do that, but to the extent that we are remembering, when we're talking about these things together, Amna said that's part of what's exciting. To the extent that we remember when we're having conversations, that a gesture can be a positive thing to just name and remember struggles that are happening that aren't necessarily in this room. I don't know that that's so terrible.
I guess just to build on that, the one thing I'll say is, it seems, I mean, I guess what's the alternative, right? I mean, one of the reasons why, so I spend a lot of time thinking about how to teach about questions of race in the classroom. And one of the things I've learned from talking to my students and to some extent discerning some things from my colleagues is the reason why a lot of people don't teach about race, and the reason why a lot of students are reluctant to talk about race in the classroom, and this is mostly a white constituency, is because they're afraid of getting it wrong, right? They're going to sound racist, someone's going to think they're racist, and so people don't want to speak, they don't want to take the risk. And teaching about race, like thinking with and about social movements in spaces that are hostile to thinking about racial inequality or hostile to mass politics, is hard. But if we don't do those things, if we don't try, if we don't experiment, if we don't hold each other accountable, if we don't say, hey, your account was too romantic, like let's get into the nitty-gritty, then I just don't see how we actually move forward. So I agree that it's riddled with risk, but I don't see an alternative to it. And I think part of the kind of hope and the ambition is to bring, and I could be accused of romanticism for this, I know, but like to bring some of that insurgency from the streets into our conversations, because that insurgency is very much feeding the instability of the state and the legal order. And it's from that instability that alternatives will and are flowing. And whether or not they win, don't ride or die with us, but we play a role just like everyone else does. And so the question is, what sense of responsibility, what sense of accountability do we feel to those things? And I think ultimately we all have to answer that for ourselves, but I hope here we can kind of try to build a space or more spaces where we can have conversations about the right or the many ways to do that.
So maybe this is a way to pivot sort of back to question to the room. Another way I think of framing what Amna, what everyone's been saying is that it may not be that we have a choice about thinking about these questions. They're putting pressure on us in ways like they've brought us to this room, right? I mean, we are brought to this room by the energy abroad, right? And the question is not, do we romanticize it by talking about it? The question is rather, what do we do with the pressures that have been put upon us that are bringing us into the thought spaces that we occupy, right? And how do we actually build our own practices around those pressures that are inevitably acting upon us, right? And so maybe romanticization is a concern, right? But it turns the question back on the room, I think, which is sort of to return to Angela's provocations, right? So what are we doing with the pressures that, like, how are we finding ourselves, right? As people upon which these pressures are acting, and then what are we doing about it?
Hi, my name is Dash. Just wanted to give another perspective on the question you were just discussing, because I think it might be interesting, because I'm not in law or academia. I worked in movement politics on the electoral side, and now I work for a supportive housing org and do tenant organizing. And throughout the conference, I personally, I really, really enjoyed it. I personally would have liked the panels to engage and gesture, however you describe it, with what's happening in social movements more. When it did happen, when there was that additional step of like, this is the legal discussion, okay, what does that mean in terms of like what we can do tomorrow? Some of the panels like took that and some of them didn't, and that was based on the topics, but I really, really enjoyed when that connection was made, even if it is imperfect, and even when, sometimes it was like, okay, it's a little bit more complicated in terms of what's actually happening. I think that discussion between the two was really, really productive.
So, Yochai Benkler. So I find your stories enormously moving. Speaking of prefigurative, as somebody who went out into the desert to found the kibbutz, that would be more utopian than the others. I know it well. But because this is the closing session, I feel that it's important to emphasize a distinct current that came through in many of the panels throughout, which is that as we seek political energy, inspiration from social movements, from people who are deeply disempowered structurally, nonetheless making their own road, making our road for us. I think throughout the panels, we've also seen what it is that is our particular power as legal scholars, as lawyers, in conversation and complement with this movement. Whether you start with Catherine's description of Taft-Hartley and the battles, that requires a certain kind of expertise that is distinctive to us to diagnose where the critical strategic losses were, to map out where the critical strategic interventions may be. Whether it's in the debate yesterday over Sharon Block and Ben Sachs's Clean State Project, and Rohan's highly technical description of what a universal jobs guarantee could look like. I think it's important as we are listening to social movements to also remember our comparative privilege and power. Our Sunrise Movement creates the impetus. Somebody has to translate that, even if at the end of the day, the senator from West Virginia slams on the brakes. Somebody has, and I think that's it's important to express that capacity to diagnose what specific institutional components are so central, to analyze why this, as opposed to that particular implementation of the reform, could make a real difference and be transformative rather than just a palliative, and then to express it in terms that can be taken over as again, with movement pushing to happen. I think it's important for us to remember that. Somebody has to know that you can dismiss something in the interest of justice.
Thank you all so much for the stories and all of the work that goes behind that. And I think part of what I'm grappling with is that if this were a crim space, I think I would know kind of how to move forward. And I think part of what's hard is the interdisciplinary challenge and thinking about what moves we make, what does organizing look like, to think of how Yochai is articulating like the expertise. Well, that expertise is pretty bounded in some ways. And so in the move, it sort of can shape which movements we get involved in. So, and yet I'm thinking of Joyce's articulation of, care not cops being both, being maybe, some people see it as a good thing, and then she's sort of destabilizing the way in which care can be like cops. And so then, okay, for people thinking about abolition, there's a sort of direct link to care and people thinking about healthcare. So I don't know, I think part of the challenge is then to really transcend disciplinary bounds and the bounds of expertise to think more capaciously. And maybe that's, one move forward.
Adding to the thanks for everyone in the room and the panel. I guess one thing, thinking about that question of sort of, given how many different domains like we crisscross in this room, one thing that I've found kind of energy and sort of engagement in is, we started a summer academy on law and organizing, and we're trying to figure out how, and actually talked to some other folks last night at other law schools who are thinking about this, like, can we bring like teaching about organizing, not law and organizing, but organizing into law schools. And I think there are some things that are going to cross many of our fields, which pick up on the conversations about the centrality of sort of mass movement power, of where power to really make fundamental changes in our legal system tends to come from, that are egalitarian in their nature. And so I think that just strikes me as one thing that should be part of our conversation, is sort of excavating how it is that many of us inside of law schools with progressive sensibilities were tutored into thinking about public interest litigation and individual representation, which all still can be very important and provide legal tools that are quite important to struggle, but that there has been relatively a sort of a turning away from conceptualizations of like how law can facilitate organizing. So thinking about the tenants union work and building from the labor union. So then there's really, I think, fertile intersections between these different fields, like with borrowing from the labor context to think about tenant organizing and power building in that way. So that strikes me as one move that kind of cuts across our different disciplinary forms. That is something that we should be thinking about where are they already happening inside of law schools, and where might they in fact happen more, and how might that provide a transit point between the sort of role of the middle-aged lawyer and the processes of movement building.
Any folks want to share thoughts in our last minutes?
Sure. Well, I guess the first thing I would say is I love a lot of things about LPE, but hands down, the thing that has been most exciting for me is my exposure to interdisciplinary set of ideas and areas of the law that, because I teach criminal law, criminal procedure and evidence, I don't think about every day. So sort of just another reason on my part to be grateful for spaces like this. Because I think it can impede bigger visions, especially if you're teaching a subject that you literally think shouldn't exist, right? That's all I do. And if that's the case, and here are, incredible theories and people living out ideas of abolition that have the entire other world of things that are not the criminal law that could be. Those I actually do think involve the state and often involve the state and involve the law. And so one needs to have a really capacious understanding of legal structure and constitutionalism and the relationship of those things to struggle. And I sometimes find myself paralyzed in that sense. And then it's spaces like this or movement spaces that I feel open and positive, optimistic, I guess I would say. And I think that goes again to our, relative knowledge and power in the things that we do and don't have knowledge about. And I think it's just that humility and sense that like we do have incredible breadth of knowledge, especially when we get interdisciplinary. But just, seeing that that's just a piece of it. And, I think Aziz talked about when in thinking about constitutionalism and maybe steps to getting toward the broader legal structures that we think could be emancipatory. The need to erect literal legal structures that allow for sustained politics that undermine dominant ideologies, or just, I think you said, make the status quo a little more harder to uphold or a little easier to get around. And I think the reason we're all here is that we think we can be a part of it. And I'm just grateful for that energy.
Yeah, I'm really grateful too. This is amazing. I just, I'm thinking a little bit with Yochai's comment, because I don't want to leave you all thinking about a kibbutz. Sometimes folks say to me, isn't all law prefigurative? Like, aren't we just creating legal realities, and some of them have the force of state violence and some of them don't? And so, one way to think about the role of legal scholars committed to enacting a different world there's no reason why expertise and prefiguration shouldn't be thought of together, including legal expertise on various levels of scale.
Okay. Yeah, I was trying to thank you so much for this. I was just thinking about your last comment about teaching a subject things shouldn't exist and the kind of interdisciplinarity here. I feel like, thank you. I feel like I was recently involved in some of this debt ceiling stuff and the minting of the $1 trillion coin. And somebody asked me at Washington Post, what happens if the Fed doesn't accept it or the Supreme Court says no? And I said, send troops to the Fed and fuck SCOTUS. And that was enough to get the Washington Post kind of very up in arms. But I think the thing that I was kind of thinking about underneath that and what you're talking about is I feel like there is such a tendency amongst law to be mild or to kind of, hold your cards or to, keep your powder dry because at some point you're going to use it. And I think at a labor conference, the idea of solidarity of saying, what does it mean to say that you want to go say, ACS are the cops? Okay, that's something we all need to now be willing to say that's a line that we're willing to support and stand by you behind on. And whether it's, striking or whatever else it is, what does it mean to act in solidarity across these disciplinary lines and holding wherever the people that we trust are willing to push up to and say, yeah, if that's where we need to agitate towards, we are all going to stand up to that line together and say that law or whatever it means to be law professors running in these kinds of spaces are willing to break those norms all the way up to that line. And, it's been great to meet everybody here and see where everyone's pushing and just willing to push with you is kind of the way I'm thinking about it at the end of this.
I guess just building on that and thinking again with Yochai's question to some extent. I mean, I agree that lawyers have expertise. I just don't agree that the expertise, as you put it, is of the sort that you were describing is singularly ours. You know, like I have friends who do anti-deportation organizing who know immigration law better than any immigration lawyer I know. So it's not, so I agree that we have it, but I think this idea that it's singularly ours, I think it doesn't seem right to me. And I think some of the kind of, I guess the reason why I'm pausing on that is because on the one hand, I think it's true that we have particular forms of knowledge that are a product of the work that we do. Like anyone who works does, you develop a form of expertise. And yet, I think we probably need to rethink how we think of our expertise and in service of what and in relation to what. In a lot of, and you know, there's like a bunch of great articles and literature on law and organizing and law and social movements and movement lawyering. And I remember in this article, I think it's by Betty Hung, who's a lawyer in Southern California. And she writes this article about like, it's kind of old, but like lessons about law and organizing. And she talks to organizers who work with lawyers to kind of get some lessons. And one of the things that one of the organizers says to her, I mean, you all know that there's maybe partly because, is it Jill Biden? Jill, is that her name? Yeah. Jill Biden massacred this this protest phrase not that long ago in a comical video, but you know the si se puede, the that workers chant. Betty Hung says that the organizers tell her, but the lawyers chant is no se puede. And so I think we have to kind of, you know, that's an old article and it's in the context of movement lawyering, lawyers who work with movements, but I think that it comes to me now because I think there's also a way in which our training counsels us against. And I didn't spend a lot of time talking about strategies and tactics broadly, but of course, partly because it's clear that formal law and politics will not deliver on responding to things that are quite popular, like Medicare for all, regulation of the environment, regulation of guns, a higher minimum wage, funding of alternatives to police, and on and on. One of the key tactics that's happening all over the country is that people are breaking the law for all sorts of reasons. They're engaging in protest. And so the question of how we relate to that and how to think about that, I think is, I mean, I don't want to, I think Amy's right, you know, like this question of legality, I think is important, but some of this stuff, and also whether it's legal or illegal, like we're seeing at Cop City, the police can arrest them anyways. So then that question of like what we do in response to that and how we relate to that, again, it's questions of like, how do we relate to our expertise to the more comfortable ways? And I know Rohan, you were pushing this as well. So I think living in these questions though is kind of the task, and to kind of keep living in them, talking to one another, holding, you know, being in conversation also obviously with people outside of our spaces, because we might just reinforce our worst tendencies.
So I think that's an apt last word for us. So thank you all so much for sticking around.